So good afternoon, everyone. We're here today to discuss the BOI Are You Ready? It's a new reporting requirement that takes effect for starting with this year, 2024. And we're going to go over at a very high level the filing requirements, the exemptions, and the deadlines that are coming up. So we'll go over some topics that we'll discuss today. Will include just a high-level overview and some key terms that will be discussed. This will also include the who, what, where, when, why of filing. So this is, which companies need to file, who has to be reported, what information needs to be reported for the individuals that are included as beneficial owners, where and how to file a report, and when they're due, and as well as why this matters, and that's mostly the penalty portion of that. So we'll go over in details for each of these categories. So to start, for those who aren't familiar, there'll be some key terms that we'll use throughout, and that's FinCEN, which is the Financial Crimes Enforcement Network. They're the bureau within the U.S. Department of Treasury that's mission is to safeguard the financial system from illegal activities. The CTA is the Corporate Transparency Act. That's a law that was passed in 2021, and it's administered by FinCEN. Its purpose is to pretty much establish a database of beneficial ownership information for law enforcement purposes. And then the BOI, which you'll see throughout, is beneficial ownership information. That's the information that's required to be reported to FinCEN under the CTA. So what is BOI reporting? So became effective 1/1/2024, and under the CTA, certain companies are required to report information about its beneficial owners, and that includes individuals who own or control 25% of the company. And we'll get into details as to what those, mean in more detail as far as what is ownership, what is a substantial control. The information that's required to be reported for these owners, it's not very extensive. It's, names, birthdays, addresses, ID numbers. So that part's not going to be complicated. It's not going to require a lot of effort, but the greatest difficulty you'll be figuring out, who is the beneficial owner and what is a reported company, and also whether any exemptions apply for companies if they are considered a reporting company. And then keep in mind, so this is for reporting beneficial owners. So it's not every owner that needs to be reported, and not everyone who needs to be reported is an owner. So there might be someone who owns less than 25%, but they have substantial control. They would be required to be reported. And the other flip side, if they, don't have any ownership at all, but they're the chief executive officer, they might be required to be reported as a beneficial owner. So ultimately, too, FinCEN's looking for individuals. So if the owner of a company is another entity, then you look to see who owns that entity. And we'll get into some details and specific examples as far as multi-tiered entities and the consolidated companies go as well. One second. So who is a reporting company? That's the first tier that we're going to figure out, and that's applies to both domestic and foreign entities. It will include all C corporations, S corporations, LLCs, unless an exemption applies. And it also has a catch-all for any other entity that's created by filing a document with the Secretary of State or a similar office. So this could include certain types of partnerships, business trusts, homeowners associations. We'll get into a little bit more details, but one of the biggest resources you can use on this is the FinCEN Small Entity Compliance Guide. This is published on the FinCEN website, and they have a little flow chart to help describe, if you're whether a U.S. company or a foreign company, and when you have to be considered a domestic or foreign reporting company. And then they also have FAQs on their website that will show some more examples and some more details as well. So if you're in doubt, after this presentation, the goal will be that, most simple structures should be able to understand if they are required to file and be able to file on their own. But for some of the more complex ones, these are two resources you can go to as well as your advisor. So some specific questions about who is a reporting company, whether trusts and foundations apply. This will depend on state law. So some states might require that a trust is required to file with the Secretary of State. Then it's considered a reporting company unless an exemption applies. The same will be true for foundations. If they're required to file with the Secretary of State, they're technically a reporting company, but we'll see later that exemptions do apply for certain tax exempt entities. So a foundation is more likely to be, exempt under that, even if they are considered a reporting company under the first analysis. And then there's reference to, the FinCEN Small Entity Compliance Guide, and the FAQs will give you more information. So whether something's a reporting company is the first step, but then there are 23 exemptions from reporting if someone is considered a reporting company. So we won't go over most of these in too much detail because based on the audience today, a lot of these won't apply. This first group includes, public companies, government agencies, banks and financial institutions. These are mostly groups of organizations that are subject to other reporting requirements, and they're actually exempt from filing the beneficial ownership information reporting. Same with investment. There's some insurance related. All these are exempt. And then these ones, so the ones in blue will be the ones we'll mostly focus on today. I'll also mention too for accounting firms, they do have a special exemption for accounting firms, but those are only if you're registered with Sarbanes-Oxley. So there might be some that have to apply if they don't fit under that, and they don't fit under the large operating entity rule. And then the ones that we'll cover today will include the tax exempt entities, the entities assisting tax exempt entities, large operating companies, and we'll get into what that means and how that is defined under the CTA. Subsidiaries of certain exempt entities. So if you're an entity that's exempt from one of these other 23 exemptions, you may qualify as a subsidiary of an exempt entity, but it doesn't apply to every exemption. We'll get into which ones are carve-outs. For example, if you're an inactive entity that has a subsidiary, you will not be able to qualify as an exempt as a subsidiary of an inactive entity, unless you have another exemption that applies. So the first one on this list is the tax exempt entities, and this can be any of the following. So it will include, organizations under 501c that are exempt from tax under 501a. It will include entities that recently lost their tax exempt status, but that only applies for about 6 months. So if your entity did lose its status, it has a little bit of leeway to try to get it back before it has to file the beneficial ownership information reporting for the first time. But then once it loses that status, it does have a certain time frame from going from exempt to non-exempt for which it has to file. And we'll get into the rules for the reporting for ones that become newly exempt entities. And then political organizations and trusts under 4947. So this one here, this is mostly going to include public charities, religious organizations, a lot of tax exempt nonprofits will be excluded here, but there might be certain ones that you might be surprised, and we'll get into like homeowners associations in particular. Wholly owned subsidiaries of nonprofits, again, there'll be a separate exception for them for subsidiaries that may also be exempt just because they're subsidiaries of an exempt entity, but it might not apply depending if there's not whole ownership. So if they're only partially owned by the tax exempt entity and they have partial ownership by someone who's not exempt from any of the other rules, those subsidiaries may have to file. And then keep in mind that short window for ones who recently lost their exempt status. There's some, I see guidance on both sides regarding entities that haven't quite gotten their exempt status, maybe a newly created entity, particularly the ones created in 2024, 2025, and maybe haven't received their tax exempt status yet. New organizations you'll see are required to file the BOI reports within 90 days of creation if you're created in 2024 and 30 days in 2025. So if you get the creation before you get their tax exempt status, there's a potential possibility where you might have to file, but that's one where I would check with your attorneys on, because the guidance I've seen has been mixed on that side of it. Just be cautious if you're forming a new tax exempt entity. So for homeowners associations, FinCEN did come out with an FAQ to make it clear that homeowners associations may be considered reporting companies. Again, it will depend first on the Secretary of State and if they're required to file a document with the Secretary of State when they're created. If so, they are considered a reporting company. And then if they're considered a reporting company, there's a possibility they might be exempt depending on what type of organization. So if it's a social welfare organization, they meet the tax exempt status, they might fall under that and not have to file BOI. But if not, then they would be considered a reporting company that's not exempt, and it has to file as a beneficial ownership information report as a homeowners association. This is actually the subject of a recent case, Community Associations Institute v. Yellen, where they were actually seeking a preliminary injunction to have the nonprofit exception applied to all the entities listed here, including homeowners, condo associations, housing cooperatives. The court just came out and said at the end of October, this is the Eastern District of Virginia, that they were not going to grant the exemption. So as of right now, all these organizations are required to file before 1/1/2025 if they were in existence prior to 1/1/24. And as unless something changes, that's the district court ruling was, they don't get an exemption. That the nonprofit exception raised, it applies to organizations that are not only nonprofit, but also tax exempt under 501A. So this one is more of a narrow exception. I don't know if too many will in the audience will um, apply for this. It's entities that are existing a tax exempt entity. And for those, they have to meet all of the requirements listed here. First, the organization has to operate exclusively to provide financial or other assistance to a tax exempt entity that was described in the prior slides. The entity also must be a United States person as defined, and it must be beneficially owned and controlled entirely by U.S. persons or lawful residents, as well as receive the majority of its funding from U.S. persons or lawful residents. So if one entity meets the criteria for this, they are exempt on their own. But this is one of the ones where if they have a subsidiary, they do not qualify under the subsidiary exemption. So subsidiaries of entities existing a tax exempt entity are not automatically exempt. They might, if they're exempt under another rule, if they were a large operating entity, then they could be exempt. But just because they're a subsidiary of this type of entity, they do not qualify as exempt, and they would have to report. One of the more popular ones that I think will apply to a lot of the audience here is large operating entity. So this is a company that employs more than 20 full-time employees within the US. They have to have an operating presence within the US at some physical location. They must have reported at least 5 million of gross receipts in a prior year. Those receipts must have been reported on an actual tax return. So it's, if you just had 5 million of receipts but you didn't file your tax return, that doesn't qualify for the exemption. And 5 million, at least 5 million of those receipts must have been within the U.S. So if you had 6 million receipts, but 2 million from other countries, you would not qualify for the exemption. So keep that in mind, that all of these have to be applied together. This is not an and or. The full-time employees, right now the guidance does not show any exceptions for like full-time equivalents or FTEs. It would be full-time employees as defined. And again, it has to have a physical presence within the U.S. And have the receipts as well. So we'll get into the next slide, how this applies, in particular, it's like consolidated groups. If they both have, they must have both 20 full-time employees and 5 million in revenue. Well, if they're part of an affiliated group and they're filing a consolidated return, the guidance for the small entity compliance guide does reference that they can use gross revenue from the consolidated return. So if you have 5 companies that are applying consolidated and revenue is 10 million, you don't necessarily have to look at what each company is making. They would meet at least the gross receipts threshold. But if you look to the next one, this comes up from the frequently asked questions from the FinCEN, is the number of employees will apply essentially on a per entity basis. So you're not permitted to consolidate the number of employee counts across consolidated entities or related entities. So if those 5 entities that are consolidated and have the 10 million in revenue, if only one of those entities has at least 20 or more full-time employees, then the other 4 do not necessarily qualify for the large entity exemption. They would have to have at least more than 20 full-time employees on their own in order to qualify for that. There is a possibility if they're all, had the same owner and they're all owned by a common entity that has the large operating exemption, then they might qualify as a subsidiary, but to do so, they must be wholly owned by exempt entities. So if it's 80% owned by an exempt entity and 20% owned by someone who's not exempt, then they have to file for BOI. And again, these thresholds apply for U.S. employees, U.S. receipts, and right now it does not seem to permit use of full-time equivalents. Something else to keep in mind if you do qualify for this exemption right now, what if the amounts fluctuate? So one of the requirements is if there's any changes into your situation, you have to file an updated BOI report within 30 days. And that will include for entities that were exempt and then become, lose their exemption. So if your company qualifies, you have 24 employees, you have more than 5 million in revenue, and you have an operating presence in the US, but all of a sudden, a few people quit, you lay off a couple, maybe drop below the 5 million threshold, any of those apply and you all of a sudden don't qualify as a point in time, you now have a 30-day requirement to file your first BOI report. So we've talked about the subsidiary of exempt entity a few times, and this will apply to someone to an entity that's wholly owned or controlled by an entity that meets one of the other exceptions, but certain exceptions will not be considered. And those are ones that are listed as 6, 18, 20, 22, or 23 on the slides. The main ones there are subsidiaries of other subsidiaries. subsidiaries of entities existing tax-exempt organizations, and then subsidiaries of inactive entities. So if you're a subsidiary of any of those, you do not qualify as exempt based on this subsidiary of exempt entity exemption. I'll go back here. So what's an inactive entity? Again, this is a very narrow definition, so not a lot will be applied here. You have to have been in existence before January 1st, 2020. You cannot be engaged in any active business. You have no ownership by a foreign person and no changes in ownership within the last 12 months. Can't have sent or received any funds totaling more than $1,000 within the last 12 months. And you can't hold any type of asset, or including ownership in another corporation. So I don't think there's going to be a lot that will apply for the inactive entity status. Something to keep in mind, and this is a question that's come up, is if an entity, say they went out of business in 2023, they filed their final tax return with the IRS, they're done on that level, but they still have not filed to close with the Secretary of State, or at least as of 1/1. Maybe even by the end of January of 2024 is when they close with the Secretary of State. They're still required to file a beneficial ownership information report for 2024. It applies to anyone that was active with the Secretary of State as of 1/1/24, regardless of what your status was with the IRS and filing a final return. So a few more scenarios for discussion, and some common ones that I think will fall through the cracks, or people might not realize they have a reporting requirement. Single member LLCs. So this is one owner, they are disregarded for tax purposes. They do not have to file their own separate return. The activities reported on the individual Schedule C, Schedule E, depending on the type of activity. They're actually required to file. So even though they don't have a filing requirement for a tax return, they are required to file beneficial ownership information reporting unless one of those exemptions previously discussed applied. And that will, that unless an exemption will apply to everyone on this list. If you have an LLC that only holds rental real estate, they have no employees, maybe they had a loss the last few years, they still have to file. So even though they're not an operating business, a lot of people set up LLCs and put their real estate in just for protection. Those are ones will all, unless an exemption applies, will be required to file the beneficial ownership information report. As we mentioned, the company filed a final tax return for 2023, they still might be required to file if they didn't close with the Secretary of State. The consolidated groups, you have to look with all the entities within the group to see on an entity level if they qualify for an exemption. So if they're a large operating entity, certain ones may qualify if they have on their own individual employee counts above the threshold, but that not everyone in a consolidated group may necessarily qualify for an exemption, even if some of them are. Entities with little or no activity in 2024. So even though these are, ones that might not have income loss, they might not have employees, those are the ones actually more likely to be subject to this requirement, because those are the ones that don't fit under the large operating exemption. And if they're set up as, a C Corp, S Corp, LLC, they will be required to file. If the number of employees drops below the threshold for large operating entities, or same with the receipts, so we discussed that, then you might not necessarily be required to file to start, but you'll have 30 days from the change to go ahead and have to file that initial report. Multi-tiered entities, so again, you're looking at every entity in the tier to see if it has a reporting requirement. Some might be exempt as subsidiaries, others, if it's a sub of a sub, will not be exempt unless it has its own, exemption that applies for like a large operating entity or a nonprofit. We'll get into one example too with multi-tiers to see just exactly how that applies. And then companies with no income. But you have zero activity at all, no loss, unless you qualify for that inactive entity and were in existence for the appropriate amount of time, you will have to file your first report. So identifying beneficial owners, so this will include ones who have substantial control or they own at least 25% of the ownership interest. So there's no maximum as the number of beneficial owners that need to be reported, but everyone will have at least one. So this will depend. So ownership part, it'll be easy to tell how many people have over 25%. The hard part will be the substantial control. And when we get to the example, you'll see how that comes into play. And what is substantial control? So this will include, senior officers, anyone who's a president, C-suite, general counsel, or similar function, typically considered to have substantial control over the entity. Someone with appointment or removal authority over senior officers, they are board members, important decision makers. With the important decision makers is a big catch-all. That will include, do you have the ability to make decisions about the selection of business lines, the geographic location? Can you enter into sales or lease agreements for the company, significant contracts? Can you transfer assets, incur major expenditures, or incur debt on behalf of the company? Do you have approval of the operating budget? Do you have the ability to determine compensation for senior officers? Or can you make any significant policy or procedure decisions? Anyone who fits in one of those buckets may consider to be having substantial control, and even if they have zero ownership of the entity, they would be required to be reported as a beneficial owner. So who will this include in particular? This is, direct ways to exercise substantial control may include board representation, and owner control of majority of the voting power, or you have rights associated with financing or interest. And then some indirect ways will include if you control one or more intermediary entities, or you have some kind of financial or business relationship or arrangement with other individuals acting as nominees. So here's an example that came up recently, tweaked a little bit, is you have a company, they're an operating company that's owned by 3 other companies. Again, FinCEN's looking for the ultimate individual. So when OpCo is looking to see if it has to report beneficial ownership information, it's not going to report company 1, 2, and 3 as its owners. It's going to look to see which individuals, persons A through F, own or control OpCo. So when going through the ownership percentages here, we get down and see that person F is the only one that has more than a 25% ownership interest in OpCo, just for the ownership side of it. So person F has to be reported, but then you have to look to see too, who are the officers of OpCo. So C, they don't have 25% ownership. They only have 25% ownership of OpCo, but they're the president. So they are also a beneficial owner regardless of their ownership percentage. And then you look to G. G doesn't have any ownership here of OpCo directly or indirectly, but G is the CFO, so G will have to be required as a beneficial owner as well. So analysis doesn't end there, because now we know who OpCo has to report, and assuming there's no other ones with substantial control, but you also have to look too, company 1, company 2, company 3 all need to file beneficial ownership reports, and who do they have to report? So, company 1 looks pretty straightforward. A and B will both be required as over 25% owners, but then also look to see who else has control of company 1, any other officers or owners. Company 2, C and E will meet the ownership requirement, but does D have any officer role, or does D have substantial control? Or is there someone else that's not listed here, no, not an owner, that has control of company 2, and then same with company 3. Now, if OpCo were a large operating entity, it would be excluded from reporting BOI, but company 1, 2, and 3 would still need to file. If OpCo owned a subcompany that was 100% owned by OpCo, subcompany would be able to be excluded under the sub of a large operating entity. But if subco further owned an entity below that, if it maybe owned a rental real estate LLC, that real estate entity would have to file BOI, because it would be a sub of a sub, and that is not exempt. Certain situations with beneficial owners is, what if it's owned or controlled through a trust? That comes up, and that will matter on the facts and circumstances as to whether certain trustees, beneficiaries, grantors, or others are considered having beneficial ownership through a trust. And some indications of control in this situation would be if a trustee had the authority to dispose of assets, if they were the beneficiary is a sole recipient of income or principal, or the grantor has a right to revoke the trust. Beneficial owners of homeowners associations, again, we went over how they are reporting entities that might not be exempt. So if no one owns or controls at least 25%, you would look to see the senior officers, those who have authority to appoint or remove officers, a majority of the board of HOA, or other important decision makers. Some individuals who are not beneficial owners will include minor children, but they would have to have their parents or guardians information reported. Nominees, those who are acting solely as employees, but that would not be an exception that applies for senior officers. And then any individual with only a future interest, such as through inheritance or a creditor. In addition to beneficial owners, you'll also have to report company applicants for any entity that was created on or after 1/1/2024. So this will not apply to those that were in existence before January 1st, 2024. We'll get into who a company applicant is. And there's 2 categories, either the direct filers or those who direct or control the filing. So direct filers is the person who physically, submitted the filing with the Secretary of State, and the direct or control is someone who told that person to do it, essentially. So all companies will have at least one person that actually filed, and then no company will have more than two. So they'll have someone who physically filed it and someone who told that person to file it. The information that's required to be reported is not much. For the company, it's its name, any doing business names, and its address within the U.S., and then the state or jurisdiction where it was formed, along with its ID number. The beneficial owners, it's similar information, name, date of birth, their residential address. So that's just one thing to keep in mind. You won't use the company address unless, for instance, you're the company applicant and you're like a paralegal that's applying at the direction of someone else. Most individuals who are reported, will be using their residential address and then an ID number. So this will be from a passport or a state driver's license along with a copy of that ID. Again, if you're a newly exempt entity, if you've already filed, you can go with BOI on the FinCEN's website and file as a newly exempt entity. The only thing you really need to do is check the box and it will gray out all the other information. And try to go through the rest of these quickly because I know we're running a little low on time. Some information that does not need to be reported. You won't have to report historical ownership or information, only what's accurate as of the time of filing. You don't have to report those with less than 25% ownership unless they have substantial control. You don't need to tell FinCEN the type of owner, so you don't have to tell them, how much ownership percentage the person has or whether it's ownership versus control as to why they're being reported. You just have to list the individuals that have either ownership or control. And then if you're in the creation before 1/1/25, you don't have to report your company applicants. And if you're exempt, you don't have to file anything to show why you're exempt. And if you're newly exempt, you file to report as a newly exempt entity. You don't have to give a reason for your exemption. Reports are going to be filed on FinCEN's website. You can go to fincen.gov/BOI. There's no fee for submission. Most people, if you have a simple structure, should be able to go ahead and file pretty simply. There are some third-party providers out there that are willing to file. They have, like FileForms has a one-time filing or subscription plans. Some of them include legal assistance for those with more complex structures. You might want to consult with your attorney. Some of them might be filing on people's behalf, but this is where you can go to file on your own. The website's actually pretty user-friendly. You go to BOI or fincen.gov/BOI. There's a big button here to file. It will, some options for help and guidance if you want to consult that first. But then you have two options. You can go ahead and file a PDF. You download the PDF, fill it out, and come back here to submit it. Or you can do it all online in one session. You don't need Adobe for that. The key one are the deadlines. So if you were in existence before 1/1/24, the deadline is coming up less than 2 months now to 12/31/24 is for the initial report. And then if a company was created or registered for the first time in 2024, they have 90 days from the date of formation. And then starting 1/1/25, if you create or register a new LLC or other company, you only have 30 days from the date of formation to file your initial report. And this is not an annual reporting requirement, but as we'll see with some additional reporting deadlines, if you were previously exempt, you are required to file a BOI report within 30 days of losing the exemption. If you filed a report and then realized something was wrong, you have 30 days to correct it. And then you're required to file an updated report anytime something changes. You have 30 days for that. And that's changes in beneficial owner information. So if the owners themselves changed, you've got new officers elected, one of the residents of the officers change. So if your CEO moves across town, all that's information that's required to be updated. And then if the entity has changes like a name change, an address change, or if they change jurisdictions that they're actually, does not apply if you're registered to do business in a new state, but if you say we're registered in California, you stop doing business there and decided to register instead in Ohio, then you would have to file for the new jurisdiction change. Why this matters and why you should pay attention to report. There's a lot of penalties for this. Civil penalties started at $500 a day, but adjusted for inflation, it's up to $591, and there's no max on that. Criminal penalties apply up to $10,000 fines plus imprisonment, and then senior officers may be liable. So even if you're not an owner, keep in mind that this is still on you to be aware of the reporting requirements. There is some disaster relief out here. I wanted to put this out there for the recent hurricanes, but keep in mind the only one that actually extends the deadline for the year-end report that's initially due for those in existence before 1/1/24 are the victims of Milton. So even as recently as Helene, that only extends the deadline for those who had a report due between September 22nd and 12/21. So that does not extend the report for those that were in existence before 1/1/24. There are some, pending litigation and federal legislation out there. So, pending litigation, there was rumors early on, CTA being declared unconstitutional by a case in Alabama, but that only applied to the plaintiffs in that case. And that case has since been appealed. So right now, unless you are a plaintiff in that specific court matter, BOI still applies. And then there's some state laws out there. New York passed one that will be effective beginning 1/1/2026, and some other states have ones that are proposed right now. So even, if you're doing business in other states, keep in mind that you may be subject to more than just the federal rules. And finally, just some key takeaways, just keep in mind that the deadline's coming up. So if you haven't filed and you haven't talked to someone yet, make sure you're understanding if you're required to file and get those in before 12/31/24. If you have any new entities that were created this year or will be created early next year, keep in mind that those timeframes for filing are based on 30 or 90 days after the date of formation. If anything changes, you have to file a report within 30 days. Beneficial owners will include those that have no ownership but have substantial control. If you have entities like a single member LLC, they're required to file unless an exemption applies. And when in doubt, contact your advisor. So we're a minute over, but that concludes today's presentation. There are some resources available if you have more information. FinCEN.gov is the best place, and you can feel free to reach out to your advisor as well. Take care and have a great day.